getting a lot of this. So it may seem like to some of the viewers that this is a very common question. Some of you might actually even be able to recite the answer verbatim, but it's still an important question because we keep getting asked this, and there's a lot of people out there that don't have the answer. And December does seem to be a very strange time when it comes to things like this, because we've received a substantial increase in this question. So Nick, there was a Vanna. Vanna was going to move out at the end of January. But then mid-month, 14th of Jan, landlord came, removed safety gates, all door locks, cut the electricity and water. And now it sounds like Van is still on the property, but yeah, so you're safe with safety gates and the door locks and water and electricity. And he has children, and you need to know what he does under these circumstances as a tenant.
Perfect. As you say, we've done this topic many times, but as it's 2023, we'll go from the very beginning again. So I'm going to assume for the purposes of the question that Werner is a tenant in the particular property. He says he's moving out at the end of January. Under what circumstances, he doesn't particularly say. But irrespective, what this comes down to is what we call spoliation within our law. So it's an established principle of South African law that no individual within the law is entitled to take the law into their own hands and enforce the law without some sort of judicial oversight or a court order. Okay, so what this means is, you can't just decide that you're going to take the law into your own hands and do whatever you want, and just enforce the law in your own particular way. We have processes for this to happen, which generally involve judicial oversight to approve the actions of a person to be taken, and also to give instructions to particular individuals to make whatever steps the court wants, which is why we have the sheriff, okay, who effects evictions. So in these particular circumstances, obviously we know that if you want to get an unlawful occupier out of a particular premises, and I'm not saying that Werner is an unlawful occupier, just for general purposes, you need to approach a court. You have to get a court order. That is the process within South Africa. There's no other way to do it. Okay. In circumstances where you take the law into your own hands, it is an action called spoliation. Okay. Now, our law protects against spoliation. Our law does not want individuals to take the law into their own hands. And what Werner has said here would clearly form an act of spoliation. So what spoliation protects against is the possession that one person has of a particular thing within the law. So there's that old adage, which possession is 9/10 of the law. This is the one thing that we're talking about. The law will protect one's possession of a particular thing, okay, until a court makes a determination that perhaps they should be dispossessed of that particular thing. Okay, so when it comes to spoliation, and this is the good old adage that every attorney learns while he's at law school, that spoliation will protect someone's possession of something, even a thief. Okay, so if a thief has something, it can be given back to them. It doesn't matter. The law will protect it and give that thing back to that person until such time as a court makes a determination, says, no, you're not entitled to that particular item. So in this particular case, Werner is obviously, he's in occupation and in possession of the premises. Okay, for whatever reason, his landlord has now come and removed safety gates and locks and cut the electricity and water. Okay, these are steps that are now detracting from the possession that Werner has of the property. Okay, now not all of these are, he kicked him out of the property. Some of these things are incidental to his possession. Okay, but certainly the act of cutting locks or removing locks or whatever the case is, and in particular, a disconnection of water, which we must remember, water is a human right in terms of our constitution. And that is something very serious to have terminated, especially as Werner says, in the circumstances where there are children on the property. These are certainly acts of spoliation, which a court is not going to approve. So what can Werner do in the circumstances? Well, it's quite simple. This is one of the circumstances, and a spoliation application is an application by its very nature that is urgent within our law. Okay, so what you would normally do is obviously you would approach attorney, or if you're not going to approach attorney, you could approach a court direct. Okay, and basically you're going to raise a spoliation application. Generally, that would involve the first thing your attorney would do is send a letter, say to the landlord, listen, you have dispossessed our client by cutting the electricity, the water, and changing the locks. We are demanding that you restore their possession to them immediately, failing which we're going to approach a court for a spoliation order. And a spoliation order, as I say, is by its very nature urgent. So your attorney can raise a spoliation application. What they will do is they will ask for a disposal of the general rules of court, okay? And they can bring the application on an urgent basis. And when we say urgent basis, we mean extremely urgent basis, okay? I have seen these particular apps. I was in possession of a property, I was using it as I was, and this person has now come and disturbed my possession of that particular property, and I want to be put back in possession of it as I was before they had taken those actions. Okay, it's very important to understand in circumstances, and a lot of our clients that come with regards to spoliation, you know, we obviously work on behalf of the landlords a lot of the time, and they say, well, you know, this person has no rights to the particular property, and they need to vacate the property. But a spoliation application has absolutely nothing to do with one's rights, and the courts will never consider rights in a spoliation application. It deals only with possession, and the court will inevitably restore possession until such time as it makes a further determination down the road whether that possession must be given up or not. But for the purposes of just keeping the status quo, they'll order this. And as I say, this can be done on an extremely urgent basis within a couple of hours if you have an attorney who's clever, and generally it's not a difficult order if there has been conduct that Werner's talking about here. So my suggestion, Werner, you know, if you can approach an attorney as quickly as possible, at least they can get a letter out to the landlord where they are demanding that possession is restored. You're only staying in the property till the end of the month, but a period of 2 weeks without water is simply problematic for anyone. So I'd approach attorney as quickly as possible, or alternatively, you can approach a magistrate's court to try and run the matter. The clerks at the magistrate's court are aware of these particular matters, and they generally assist people who walk in. But obviously, that's a process of bringing the case by yourself, which is obviously a little bit more difficult in the circumstances, as your attorney is going to know exactly what to do and how to expedite the process as quickly as possible.
Awesome. Yeah, that's absolutely, yeah, that's perfect. And it is just one of those things. So landlords beware, and tenants, yeah, like know your rights. And I suppose it just basically comes down to that. Yeah. Cool. Awesome. Thanks so much, Nick.
Hundreds. Thank you.
Cool. Good luck with the load shedding.
Yeah. Thank you. You too. Good luck to us all. All right. See you next week, Bruno. Cheers.
Bye.